If you have not watched the intro to this series, please pause the video now and do so before continuing. In this video, as the title suggests, we'll be comparing the treatment of female captives in Deuteronomy and Islamic law. Deuteronomy 21:10-14 states, "When you go out to war against your enemies, and the Lord your God gives them into your hand, and you take them captive, and you see among the captives a beautiful woman, and you desire to take her to be your wife, and you bring her home to your house, she shall shave her head and pare her nails, and she shall take off the clothes in which she was captured, and shall remain in your house, and lament her father and her mother a full month. After that you may go into her and be her husband, and she shall be your wife. But if you no longer delight in her, you shall let her go where she wishes. But you shall not sell her for money, nor shall you treat her as a slave, since you have humiliated her." Rape of female captives was common on ancient battlefields, and of course the question is whether or not this is allowed under the Mosaic law, particularly here in Deuteronomy. First, some background knowledge. With respect to captives from the enemies mentioned in verse 10, this is an exclusion to the marriage of Canaanite women, which is forbidden in Deuteronomy 7 due to the abhorrent practices of the Canaanites. I've elaborated on some of these in other videos in this series. It is possible that the law was understood as requiring the women to convert to Judaism for the marriage to actually occur. More on this later. If a man wants to take a wife for himself, he is required to provide for her from his own resources during the mourning period in verses 12-13. As a side note, some rabbis, like Rabbi Akiva, for instance, say that the full month in verse 13 actually refers to 3 months. 3 months would be more consistent with what we expect, given this was a more typical time frame to determine if a woman was pregnant or not in a pre-scientific age. In this case, we may be looking at a Hebrew idiom where a full month actually refers to 3. I won't argue for or against this since it's not particularly relevant to this video, but it's an interesting side note nonetheless. According to some commentators like Rabbi Rashi, the clothes which she was captured in verse 13, refer to the ancient custom of Gentile women in times of war dressing very attractively and provocatively to seduce enemy soldiers away from victory. In contrast to this seductive beauty, the woman was made to appear unattractive by putting on clothes of mourning consistent with Israelite customs. According to Talmudic exegetes, this could be for one of two reasons. Marrying a woman because of her beauty alone was highly discouraged. As such, she was made to appear unattractive. Or this may be symbolic of shedding her previous life among a pagan nation. In addition to these possibilities, the ultimate purpose of shedding the clothes of her captivity is to be in accordance with Israelite customs of mourning, as the text plainly states, which included a particular style of distressed adornment common in the ancient world. Also, with respect to verse 13, Tigay notes in his commentary on Deuteronomy on page 194, since verse 13 does not mention a husband, for whom a married captive would surely mourn, the law possibly has only unmarried women in mind. This is certainly a plausible inference, but as Deuteronomic law is not meant to be exhaustive, Tigay correctly does not state this definitively. If the man chooses to divorce the woman, he was not allowed to sell her as a slave, verse 14. This is significant because the man has nothing to gain monetarily by divorcing her. It's not a situation where the man has nothing to lose and everything to gain. With nothing to gain by divorce, this increases the level of responsibility required of the man in marrying the woman in the first place. Also, for verse 14 regarding the phrase, "if you no longer delight in her," some commentators interpret this phrase homiletically as a caution. Again, Tigay notes this in his commentary on this passage. The idea being that if a man sees a beautiful woman and because of that desires to marry her, he's doing it for the wrong reason, and the marriage will eventually fail. Regardless, this phrase shouldn't be taken trivially. Deuteronomy regards the sanctity of marriage very seriously in chapter 22, verses 13-21, for example, which restricts the husband's right to divorce a wife he doesn't like for superficial reasons. With respect to the passage as a whole, I'll quote from Christopher Wright in his commentary on Deuteronomy, page 234. He says, "There are 4 ways in which this law benefits the captured woman. A. She is not to be raped or to be enslaved as a concubine, but is to be accorded the full status of a wife," verses 11 and 13. The instruction in Hebrew is quite clear that only marriage is intended. B. She is to be given time to adjust to the traumatic new situation and to ritually mourn for the parents who are now dead as far as she is concerned. This is to take place within the security of her new home, not in some prisoner or refugee camp. C. The law compassionately restricts even the soldier's, quote, bridegroom rights by postponing any sexual intercourse with the woman until this month of mourning and adjustment is over. D. If the man finally changes his mind and will not undertake marital responsibility towards her, she is to leave as a free woman. He can take no further advantage over her by selling her as a slave. Thus, the physical and emotional needs of the woman in her utter vulnerability are given moral and legal priority over the desires and claims of the man in his victorious strength. Admittedly, Wright has a rather glowing review of this passage, which at first appears incredibly harsh to our ears. I want to pose a few questions of the text as well as some plausible answers to see if the positive opinion of this passage we just heard is warranted. Number 1, does the text allow rape on the battlefield as was typical for the time? No, this is prohibited by verse 13, which says after the things in the previous verse have taken place, only then can the marriage legally occur. Battlefield rape is obviously prohibited. The next couple of questions I will pose have to do with arguments frequently expressed by critics as well. Does desiring her in verse 11 refer to rape? This argument comes to us from an Islamic source via the website answering-christianity.com in an article entitled Biblical Law Permits Rape of Female Captives, written by Kevin Abdullah Karim, and cites Young's literal translation, which is a 19th century work from a self-taught linguist. Young's translation says, "For verse 11, hast delighted in her." Karim then, without any textual evidence, says that this is an idiom for rape. Quote, "The expression, and hast delighted in her, is a reference to sexual intercourse by force." To substantiate this astonishing claim, which apparently for him has materialized out of thin air, he cites Matthew Poole, who says in a source not cited in the article, "Hast taken delight in her," which may be a modest expression for lying with her. So Karim first states out of nowhere that delighted necessarily means intercourse by force, and then he quotes a 17th century commentary which does not even reinforce his claim. Additionally, Karim fails to address the entire text. As I indicated in my answer to one above, there is a sequence of events which must take place prior to sexual intercourse. Further, the attitude in Deuteronomy toward rape is that it is a crime worthy of death. More on this later. Finally, the text itself defines what desiring her means, to quote Deuteronomy 21:11, "And you desire her, and would take her to wife." So the desire is unto marriage. Much to his discredit, Karim decided to reach back in time to a 17th century commentary, which, by the way, he misconstrues, instead of simply allowing the rest of the verse itself to guide his exegesis. Question number 3. Does the Hebrew word for humiliated, defiled, or alternatively made low in verse 14, depending on the translation, necessarily imply rape? This argument refers to the Hebrew root for the word translated humiliated or defiled in verse 14, and says that this meaning implies that the defiling refers to a prior rape, which then would be implicitly authorized by the passage. However, this is not at all true. Professor Ellen Van Wold, for example, published a profound article examining this word entitled, "Does Inah Denote Rape? A Semantic Analysis of a Controversial Word." This article is available online from academic resources. I was able to easily obtain a copy for free, and I encourage others who are further interested to do the same. In this article, she states, the previous series of actions, her being taken captive, her transfer into an Israelite household, the sexual intercourse, all these actions are resumed here with the verb inah. It does not reflect illegal or illicit sex because the previous verse showed that this intercourse was acceptable. This evaluation with the term inah is presented in combination with the spatial preposition tahat, under, she whom you bowed down, and it is said the moment she is in danger of being discarded, sold as a slave. However low her social status may be, she is not to be degraded. In sum, this text does not talk about rape, but about an accepted form of sexual intercourse in Israel between an Israelite man and a non-Israelite captive woman. Does verse 13 allow the man to have intercourse with a woman even if she resists after the mourning rites are completed? Having demonstrated that the text itself, lexically and philologically, does not refer to the woman being raped, I want to further reinforce the answer to this question, which is in the negative, by examining a passage that gives us a very good indication of the attitude Deuteronomic law takes on the protection of women. There is much going on in the verses surrounding the passage I'll be citing, and I won't be addressing these issues since it's beyond the scope of this video. But for now, I do want to stress that while critics of Deuteronomy often issue scathing rebukes of the law, in doing so they only demonstrate a fundamental misunderstanding of the text as well as no knowledge of the context of the ancient world. Again, I won't be addressing these misunderstandings where they occur elsewhere in the surrounding text, but as we proceed through the passage I'm about to comment on, a new understanding will emerge for those who previously lacked sufficient background knowledge, which will demonstrate how easily Deuteronomic law can be misunderstood by the modern English reader, and how a more thoughtful and informed approach is required. Deuteronomy 22:25 through 27 states, "But if in the open country a man meets a young woman who is betrothed, and the man seizes her and lies with her, then only the man who lay with her shall die. But you shall do nothing to the young woman. She has committed no offense, punishable by death. For this case is like that of a man attacking and murdering his neighbor, because he met her in the open country, and though the betrothed young woman cried for help, there was no one to rescue her." This passage is in contrast spatially to the one which precedes it. Deuteronomy 22:24 refers to not crying out for help, though she was in the city. Now, there were obviously other people present in these very close communities within walled cities in the ancient world, and the text, which is only meant to establish the general structure of the law, simply assumes people are within shouting range, and the woman did not cry out for help because if she would have, it would have been heard. So the text is a contrast of two, what today we might call basic or even simplistic scenarios. These scenarios are contrasted in two cases. Number one, illicit, consensual, sexual intercourse. How do we know? Again, the reason seems simplistic to our ears, but it was because the woman had the chance to call for help within the walls of the city, and she did not. Since she offered no protest, she is not allowed to claim to the court, after the fact, that she was raped. The intercourse is judged to be consensual. So, whereas this prevents the woman from avoiding the legal penalty for illicit, though consensual intercourse by claiming falsely that she was raped, the next case addresses a scenario where a woman is unable to substantiate her claim. It is in the open country where there is no one to rescue her. Now, there is a very obvious but frequently overlooked provision made in this law. In the open country, if a woman is raped, she can produce no witnesses. As the text assumes, there is no one to rescue her. However, significantly, the text clearly states that the man can be put to death. This is why Muslim critics are extremely misguided in pointing this verse out as a criticism of Deuteronomic law, implying that through this verse, at least in part, somehow rape is not condemned under the Mosaic law. They fail to think this through. In the ancient world, witnesses in court were extremely important, much more than they are today. Take rape, for example. We can easily convict a rapist, even a very clever rapist, who has managed to construct a very plausible alibi, if the DNA evidence supports it. We would think nothing of a newspaper headline that states, "Rapist pronounced guilty with no witnesses to the crime," if the DNA evidence was substantial. Not so in the pre-scientific ancient world. Witnesses were crucial in criminal proceedings. Consider this law from the Middle Assyrian Code, Tablet A. If a married woman was walking on the street and a man has grabbed her and said to her, "Let me have sex with you," and if she was not willing and defended herself, but he has taken her by force and raped her, whether they catch him on the wife or they have testimony that he forced her, the elders are to have him executed. The woman is not to be held responsible. Now, as with the Torah or any other legal code, it should be noted that these are far removed from our cultural context, and it is improper for us to read into the text more than we should. For example, the law specifies married women. May we infer a priori from this that there was a sort of free-for-all on unmarried women? I think not. Likewise, the law implies very strongly that, to be prosecuted, the man has to be caught in the act on top of the woman, or as a lesser, more indirect means of proof, that on the basis of witnesses, the woman's lack of consent prior to the act could be established, thereby condemning the man to death. Notice that I'm not saying that in the absence of the minimum required number of witnesses, that the judges would reject this case, but it does appear, from a face value reading of the text, that it was only by proof ascertained by one of these two methods that the man's guilt was sufficiently confirmed, and he was to be sentenced to death. And though we want to be very sympathetic to the claims of a woman who says she was raped, the fact remains that the penalty is final capital punishment. And given the nature of the penalty in the context of a pre-scientific world where evidence consisted of eyewitness testimony, we must also be sympathetic to the fact that the law is concerned, as it clearly states, with establishing proper proof, in that, as a general rule at least, the code requires witnesses to attest to the crime before the man can be put to death. This emphasis on witnesses is clearly present in the Deuteronomic text as well. A single witness shall not suffice against a person for any crime or for any wrong in connection with any offense that he has committed. Only on the evidence of 2 witnesses or of 3 witnesses shall a charge be established. However, it will be apparent by now to the careful reader that in the open country, cited in Deuteronomy 22:25-27, the text clearly is conveying a situation where no other people, and therefore no witnesses, are present. However, the law prescribes the death penalty to the man. Therefore, this penalty would be handed down on the basis of the woman's testimony alone. This is possibly an exception to the Middle Assyrian law cited above, and certainly an exception to the general rule for 2 to 3 witnesses minimum prescribed in Deuteronomy 19. The text condemns rape in yet another way. Aside from prescribing capital punishment, it compares ambushing a woman and raping her to murder. For this case is like that of a man attacking and murdering his neighbor. Not only does it condemn rape via capital punishment, and by comparing it to murder, it goes beyond other provisions of the law and allows the man to be prosecuted according to the investigation and evaluation of the judges adjudicating the case. The judges are not allowed to reject the woman's claim even though no witnesses other than the woman's can be produced, and this is why Muslims should stop using any arguments related to this text. This is in contrast to Islamic law, where a woman's testimony is held in very low regard, worth half that of a man's, if it is accepted at all, apparently because she is intellectually deficient. Not only does Deuteronomy 22 controvert the claims of Muslim polemicists that Deuteronomy does not prohibit rape, it further backfires because it regards the testimony of a woman far superior to Islamic law. Finally, notice very importantly for those who want to limit this law to events that occur in the open country, that when this text compares rape to murder, it brings the context back from the open country into the city. It compares the case to that of a man attacking and murdering his neighbor. In the end, the law eliminates any such notion of spatial distinction. The text makes clear this is a concern inside the city as well. For an Israelite man who rapes a woman in isolation affects his fellow men and women in the same way as a man who murders his neighbor. For those who want to claim this law is only applicable to special geographical circumstances and does not apply to day-to-day life in ancient Israel, they would have to contend with the fact that the law brings the crime back home, so to speak, back inside the city walls of the community it affects. Thus, the position Deuteronomic law takes on a man raping a woman is one which compares it to murder, requires capital punishment, and even expands protection for women by portraying all of this in a worst-case scenario in which the death penalty is prescribed even with otherwise insufficient witnesses. It further speaks to the trauma of rape, not only for the woman but for society, stating the rape of a woman in isolation is as reprehensible as a man killing his neighbor in the immediate community. At this point, I have demonstrated from Deuteronomy 21:10-14 that the text does not, in fact, imply rape. Further, I have demonstrated that Deuteronomy 22:25-27 has much more depth than one might initially think. This seemingly shallow text, which apparently condemns rape only in certain arbitrary circumstances, in reality condemns very strongly rape in any context. But in the scenario in which the law is presented, several important additional principles are able to be succinctly communicated, not the least of which includes an additional provision for women who cannot produce witnesses, and the relation of a crime of raping a woman in a remote area to the murder that occurs within the city, which speaks of the high regard the law maintains for women. I will add one final note about why the text specifies a betrothed woman. This is frequently misunderstood, and all sorts of erroneous conclusions are drawn from it. However, the specific requirement of betrothed women in this verse is not some sort of open season on women who aren't betrothed, as some crassly suggest. Rather, ancient Near Eastern legal codes frequently refer to rape in cases of unmarried or betrothed women, as Dr. T.K. notes in the JPS commentary on this passage. This is most probably due to experience at the time, having to do with how and when marriages were arranged in their culture. Their legal codes were written to address their issues at their time. Having firmly removed rape from the possibilities in Deuteronomy 21:10-14, both textually and from other legal codes in Deuteronomy, other questions remain, assuming, for the sake of argument, that the woman could be forced to marry against her will, as opposed to intercourse against her will, which we previously discussed. How are we to understand the practical application of this law? Would she despise her potential husband, or would she see this as an opportunity to increase her social status, from a captive of war to a wife? What if the woman, in addition to resisting intercourse, resisted the mourning rites or the marriage? Would the marriage still be permitted if the woman refused to convert to Judaism? Is Deuteronomy 7, which seems only to be prohibiting intermarriage with Canaanites, to be extended to other nations as well, as could be argued from the geographical context in which the law was issued? Indications of this occur in the prophets, and very clearly in rabbinic thought. These are all valid questions, but I choose not to speculate about how a woman would react in such a case. The culture and practices are far too removed from anything we're familiar with today. And regarding the woman resisting the marriage by some method, perhaps refusing to comply with the mourning ritual, or refusing to convert to Judaism, what was to be done then? Again, a valid question, but I will leave them to the rabbis. I will not argue beyond what I can ascertain from the text. Critics should take note and do the same. My purpose here is more modest. I am not trying to give the listener a warm, fuzzy feeling about the passage in question. War, the context in which this passage occurs, is a brutal thing, especially on ancient battlefields. War and the things that concern it should leave us unsatisfied, feeling like the opportunity for a soldier to marry a captive woman should not even present itself in the first place. But my purpose is to demonstrate that in the inevitable occurrence of a soldier taking a captive woman, the Mosaic law discourages it from the start, hence the requirement to make the woman unattractive, thereby nullifying the very thing that motivated the man in the first place. Further, it protects her from being raped. It gives her the right to mourn, and provides the opportunity of being welcomed into the Israelite community with full rights and protection under the law. The analysis of the Islamic perspective on this issue is much more straightforward. Muhammad is the best interpreter of the Quran, the source of much of Islamic law, and the early companions acted out his laws authoritatively. We have multiple practical examples that inform us of how Islamic law was understood and practiced on this issue. The Quran several times mentions sexual relations with women owned by men. Certainly will the believers have succeeded, and they who guard their private parts, except from their wives or those their right hands possess, for indeed they will not be blamed. Surah 4:24 and 70:30 state similarly. Now let's see how this plays out. The Prophet sent Ali to Khalid to bring the kumis, and I hated Ali. And Ali had taken a bath after a sexual act with a slave girl from the kumis. I said to Khalid, "Don't you see this?" i.e. Ali. When we reached the Prophet, I mentioned that to him. He said, "O Buraida, do you hate Ali?" I said, "Yes." He said, "Do you hate him? For he deserves more than that," from the kumis. So kumis here refers to a certain amount, typically 1/5 of the spoils of war going to the Islamic State. The slave girl was considered part of the spoils of war, and here Muhammad said Ali deserved more than just a sex slave from these spoils. And so Buraida had nothing to be angry over. Notice Buraida wasn't angry over Ali having sex with the slave. He was angry that Ali had appropriated some of the spoils of war for himself. This would have been a great time for Muhammad to prohibit this practice and punish Ali under the code for illegal sexual intercourse, except that this slave girl was part of the spoils of war. As such, she was a woman whom Ali's right hand possessed, and women whom your right hands possess are not forbidden under Islamic law. We went out with the apostle of Allah and took some Arab women captive, and we desired the women, for we were suffering from the absence of our wives, and we wanted ransom. So we intended to withdraw the penis while having intercourse. So we asked Muhammad about it. He said, "It does not matter if you do not do it, for every soul that is to be born up to the day of resurrection will be born." Again, some of the companions of the apostle of Allah were reluctant to have relations with the female captives because of their pagan husbands. So Allah the Exalted sent down the Quranic verse, "And all married women are forbidden unto you, save those captives whom your right hands possess." This conveniently removed their reluctance to have relations with the female captives. Now, if you don't consider Sunan Abu Dawud very authoritative, that's fine. I can read it from Bukhari as well. A similar situation arises. They were Arab captives, and we decided the women in celibacy became hard on us, and we loved to do coitus interruptus. So when we intended to do coitus interruptus, we said, how can we do coitus interruptus before asking Allah's messenger, who is present among us? I have to pause here to note that this is an utterly astonishing question, which betrays the barbaric intentions of these men. And when they asked Muhammad about this, he said, "It is better for you not to do so, for if any soul is predestined to exist, it will exist." So in other words, no, don't practice coitus interruptus because it's up to Allah anyway. Or again, "O Allah's messenger, we get slave girls from the war captives, and we love property. What do you think about coitus interruptus?" Now, why were they worried about this love of property and so forth? It turns out they were planning on selling the women as slaves after they were done with them, and they were worried about diminishing their profits if the women got pregnant. We captured some noble Arab women. We had been away from our wives for too long, but we also wanted the ransom, so we wanted to have intercourse with them and then withdraw. This is paralleled in Bukhari. We get female captives as our share of booty, and we are interested in their prices. What is your opinion about coitus interruptus? The questions the companions have are not about the impropriety of sexual relations outside of marriage. Their questions aren't regarding the appropriate mourning period for these captives of war. They do not ask whether this act obligates them to marital responsibilities, and they don't seem to be concerned about whether or not the woman's permission is given. Their questions only involve coitus interruptus with regard to the captive's husbands, as well as diminishing prices if the captive woman gets pregnant. Muhammad never attempts to correct the presuppositions that lie under their questions. It is indicated elsewhere that a woman who is possessed by a man's right hand, to borrow the Quranic language, is not required to give her permission, but that intercourse is the man's right as her owner. The Prophet admired Ibrahim, who was fair-skinned and beautiful. He used to visit her and ordered her to veil herself, but he had intercourse with her by virtue of her permission. No, by virtue of her being his property. When she became pregnant, her time was due, she gave birth. That's History of Al-Tabari. This is also echoed in part in Surat Rasul Allah, mentions 4 slave girls of Muhammad, one of whom was Mary, the mother of Ibrahim, the apostle's son. This is consistent with the Islamic view towards women as property as well. Your wives are a tilth, an agricultural field, to you. So come to your tilth however you will. For more on women as property, see my series of videos on women in Islamic ideology. So let's contrast some of the points discussed in this video. First, sexual relations independent of marriage. In Islamic law, absolutely. No marriage is mentioned whatsoever. In Deuteronomy, this is not the case. Is a mourning period allowed for under Islamic law? There's no mention. In Deuteronomy, yes. Obligation to marital responsibilities? No, in Islamic law. Yes, in Deuteronomy, intercourse by right or consent, by right in Islamic law as the man's property, and in Deuteronomy by consent. We covered the Deuteronomic perspective towards forced sexual intercourse. Divorced captives allowed to be sold as slaves. I have divorced in parentheses since in the Islamic view, these captives are not required to be married. They are in the Deuteronomic view. Were they allowed to be sold as slaves in Islamic law? Yes. And in Deuteronomy, no, they were to be released as free women under equal protection of the law for both Israelites and foreigners prescribed in Deuteronomy. This should be a rather startling development for Muslims, given the blatant superiority of the ancient Mosaic law over Islamic law given many years later. It seems the ethical and moral framework of Allah and Muhammad declines over time in comparison. Though Allah endorses the Torah in several places throughout the Quran, as does Muhammad in the Hadith, they don't seem to have incorporated much of it vis-a-vis the rights of female captives into Islamic law.